and gentlemen, okay, we are in live video. One is playing this video. Well, so ladies and gentlemen, today's session on point of the topic, rich. Okay, we are in live video. Okay, one is okay. Let's move. The topic, the burning topic or the hot topic is writ. So the history prescribes that writ, the origination, or the writ is originated in UK, England, to govern the servant of the UK. Now the question may arise before us, what is writ? A writ is a formal. A writ is a formal legal documentation. Yes, of course, this is a document. There's several types of document. Our main discussion media or the thematic approach in this session is writ. A writ is a formal legal document drafted by courts that commands an individual or entity to conduct or stop doing a certain actions. Indeed, the right to a writ is a crucial legal remedy that citizens have when their fundamental rights have been violated, such as by an illegal act of government. Of course, this is the illegal act of government in every inch of the land. That the practicing power from the side of the government, whether this is the Awami League, BNP. This is the outcome in our society that the Aina got answer the Hawa Bhavan. So there is no doubt in this respect. The right to a writ is a crucial legal remedy that citizens have when their fundamental rights have been violated, such as by an illegal act of government, a legal error, etc., in order to enforce apply the substantive law. According to Article 102, this is the wrapped constitution of the People's Republic of Bangladesh. Constitution. This right is exercised in Bangladesh by submitting a written petition. Petition, wow, exactly the petition or writ petition to the High Court Division of the Supreme Court, asking for the court's recommendations or rulings on the topic. Here, this is the wrapped constitution of the People's Republic of Bangladesh. Wow, we're hearing system. Actually, the excellent voice is hot. So Article 102 of the People's Republic of Bangladesh prescribes that this right is exercised in Bangladesh by submitting a writ petition or writ petition to the High Court Division of the Supreme Court asking for the court's recommendation or rulings of the topic. The opposing parties or respondents have been summoned by the court and ordered to do or to refrain from doing something. Well, wow, we're hearing system actually okay, there are 5 types of writs in Bangladesh. For example, this is the habeas corpus writ. It's very much important in coming 2025 High Court formation exam. That's the habeas corpus writ, which is found in 491 of the Code of Criminal Procedure. So it's well known to you, this is the writ of habeas corpus, and then the second was this writ of certiorari. And then a writ of mandamus, or the writ of prohibition, what exactly the writ of quo warranto, and then the discussed media in terms of that. First, I would like to uphold my voice in terms of writ of habeas corpus. So, how can we actually understand or comprehend that the writ, the first type of writ in Bangladesh is referred to as habeas corpus, is Latin for to have his body or her body. Since 1640, 1642, this law has protected liberty of British subject, of course. This is the origination, that the writ is originated from the British, UK. So this law has protected the liberty of British subjects against their unlawful imprisonment in public or private custody. So this is very much important for you. Exactly, the history prescribed that. The King's Bench issues a writ of habeas corpus to determine if an individual was unlawfully detained in accordance with subclause 1 of subclause B of subclause 2 of Article 102 of the Bangladesh Constitution. Of course, this is the Wrapped Constitution. This is not the Holy Constitution. The High Court division upon the application of any person. It is a main point, please, here. It is a core point to comprehend that the nature of that very writ like this, the writ of habeas corpus, is that the High Court division upon application of any person. So underline this, and that should be kept in your mind with the faculty like this, the CPU, Central Processing Unit. Again, please. Let's move. The High Court division upon the application of any person directs that a person in custody be brought before it so that it may determine whether he is being detained with or without legal authority. Well, illegally detained individuals may be filed petitions for the writ of habeas corpus. For example, in the landmark decision when the genius teacher Taposh Kumar from the side of the Russia University or the University of Russia, Taposh prescribed that state versus DC Shatkira. So the 46 DLR prescribed regarding this aspecting approach from this side. Illegally detained individuals may file a petition for the writ of habeas corpus. So illegally detained individual may be file a petition. Well, however, if the petitioner is unable to make such an application, any other interested party may do so on his behalf. Thus, a wife, a father, or even a friend may apply for the writ of habeas corpus in such situations. Oh my God. So any person may file this type of writ petition to the High Court division. Oh my God. So it is very much important to understand that. There are 5 types of very much important. It's very significant. Every request for writ of habeas corpus must be accompanied by an affidavit detailing the facts and circumstances that led to the request. If the court determines that there is a prima facie case for granting the petition, it will issue a rule directing the detaining authority to show cause on a certain date. Why the ruling should not be made absolute? Of course, there is nothing in the world absolute in nature. Nothing is in the world. Nothing is absolute in the world. This is the habeas corpus, which is very much important in coming 2025 High Court formation exam. That's the habeas corpus, which is for. The court will assess the merits of the case and the issues and appropriate whether on the specified date. But this is any person actually. There is an option for the any person who file a writ petition to the High Court division in terms of writ of habeas corpus. Every request for writ of habeas corpus must be accompanied by the affidavit. Wow. Detailing the facts and circumstances that led to the request. If the court determines that there is a prima facie case for the granting the petition, oh my God. If the court determines that he is in being unlawfully detained by the authority, it can declare that authority to be without legal jurisdiction. Section 491 of the Code of Criminal Procedure also permits the High Court Division to issue an order in manner of its writ of habeas corpus to summon a person imprisoned. Oh, oh my God. It is well known to you exactly if the court determines that there is a being unlawfully detained by the authority. It can be declared the authority to be void, illegal jurisdiction. Section 491 of the Code of Criminal Procedure 1998 maybe also permits the High Court Division to issue an order in the manner of writ of habeas corpus to summon a person in prison in public or private custody before in order to determine whether he is being detained illegally or inappropriately. If the High Court Division determines that the detainee is being detained illegally or improperly, it orders the detaining authority or the person to release him or her. Kohinoor Kitcha. So this is the Moina Begum or the Kohinoor Kahini or the history of escape, that is State versus DC Shatkira. So the case reference, will be prescribed from the side of the Chennai State of Bush Kumar. Again, Azizul Haq versus Bangladesh 42 DLR 189. This is the landmark decision in terms of the writ of habeas corpus, exactly. So in this case, it is quite clear. So when a specific criminal accusation has been lodged and the specific criminal case is ongoing, the executive authority should not commit resist to preventive detention. The administrative authority has a solemn constitutional commitment to assist the Supreme Court. So under article authority, there is a safeguards as to arrest and detention. It is well known to you exactly. Now, another landmark decision is Habiba Mahmood versus Bangladesh 45 DLR, maybe Appellate Division 89 at page 89. So, the court must maintain a balance. Oh my God. What type of balance it is? The court must maintain a balance between the state's duty to prevent harmful actions and the citizens' right to personal freedom. Oh my God, personal freedom. No one is escaped from the arbitrary power. So the personal freedom is not being practiced in our country at all. So this is the hypothetical media, Habiba Mahmood versus Bangladesh 45 DLR. Appellate Division 89 phase. At phase 89. So the court must maintain a balance between the state's duty to prevent harmful actions and the citizens' rights to personal freedom. Government of Bangladesh versus Shahid 440 DLR Appellate Division 178. This is the landmark decision. And the far-reaching effect in this very case, important or the significant is the reality of detention, not the date of the word for the detention. 1642. This law has protected liberty. So this is very much sham for the nation. And the landmark decision, Bangladesh and others versus Jamil Haq, 1 BLD Appellate Division 488. So that landmark decision are the only, exactly the only thing that can be asserted is that the grounds on which a court martial established under the Army Act can be challenged by habeas corpus will be analogous to those available under Article. So we don't actually comprehend the impact or the nature of writ petition to the High Court Division. So the Bangladesh and others versus Jamil Haq 1 BLD Bangladesh legal decision, maybe Appellate Division 488, maybe the page number. Prescribed that, so the only thing that can be asserted in is that the grounds on which a court martial established and the Army Act can be challenged by habeas corpus will be analogous to those available under Article 102, subarticle 5 of the Constitution. Not there is a subsection, there is no option to tell this the article instead of what can say, instead of article, no one allowed to speak in such way that the section. Some leading cases on preventive detention in Bangladesh includes, for example, Farzana Haq versus Government of Bangladesh. This is the raising effect as Sanallah Haq knew. How much times, many times he had been arrested. He was arrested, for example, in 1986 and then 87 and then 1988. Oh my God, then 1989. Several times he was arrested and sent to the jail. What an arbitrary fucking approach in terms of the preventive detention. And the Bilkis Akhtar Hossain and Cabman said Abdul Latif Mirza versus Bangladesh, that the glaring example in our country, Habiba Mahmoud versus Bangladesh and others, and Tahira Nargis Said versus DIC prison Dhaka, those are the landmark decisions in our country that the living and the, what can say, that the justice cries far too long, with the capturing power in terms of preventive detention, that the arbitrary power from the side of the executive organs of the government. So this is the Kusuni that the Kusuni versus Madras, State of Madras, All Indian Report 1959, Supreme Court, at page 725. This is quite clear. One is the fundamental rights are violated. And this is the obligation from the side of the constitutional mandate. So this is that should be ensured from the side of the what can say constitutional approach. In this case, the Kusuni versus State of Madras, All Indian Report 1959, Supreme Court 725 page. Well, the Ramesh Thakur versus State of Madras, All Indian Report 1959, the Supreme Court 124. This is all the same approach will be applied in this regard, that the systematic way. So not only that, this is the several case law, like another made of course we have all known in this regard. So the systematic way, the code of now the question may arise in terms of writ of certiorari. Well, writ of certiorari. No one's watching this video, so how actually we actually share, so this is very much important, the significant approach, but someone said it's so very much difficult for us not to understand this is the language. So no one is actually able to understand, and that's why the live video actually is vast. Only 5% of the 3%. So this is very much shame for the whole nation, exactly. Okay, no matter how I so even. Now I would like to discuss in terms of writ of certiorari. Certiorari is Latin meaning the to be certified. To be certified. So how actually to certify something? Or to be more completely aware of. Initially, certiorari was a court order. Initially, certiorari is a court order. With the passage of time, but exactly with the passage of time, the scope of this writ was expanded to exclude, of course, it is include, not to exclude that judicial, quasi-judicial and even administrative power. This writ power enables the High Court Division of the Supreme Court to control the actions of the inferior or subordinate courts. For example, to determine whether the subordinate courts in Bangladesh are operating within this jurisdiction or beyond it. What exactly is the jurisdiction of the code? So jurisdiction of the code means that the powers, it's a court's power to decide a case. This is totally comprehended, that the jurisdiction. So there are several landmark decisions in this regard, like this official trustees versus Shachindro. It may be that the Raja Shop Factory versus Raja Shop Factory versus SP Shantras maybe. So those are the landmark decisions in terms of jurisdiction of the codes. So jurisdiction means a court's power to decide a case. So it is quite clear, a writ of certiorari may be submitted. It is our turn to make you understand that. A writ of certiorari may be submitted by the aggrieved party. So what is the difference between the two? First of all, I would like to uphold my voice to you that the writ of habeas corpus, well, there is no, what can say, aggrieved party is needed to actually file the writ petition to the High Court Division. But on the other hand, on the contrary, that the writ of certiorari prescribed that, well, a writ of certiorari may be submitted by the aggrieved party. Or in some circumstances by anyone against a lower court, tribunal, or authority that abused its power or breached the principle of natural justice. So what exactly the natural justice exactly? We don't know. In earlier we have Advocate Joinal Abedin Shohel prescribed Assalamu alaikum, peace be also upon you. Peace be also upon you. I'm in lab class, Mr. Join Alabedin, I will discuss with you after finishing this lab video. So the MEDA has come into force. There's a far distinction between the two exactly. Writ of habeas corpus. In this regard, there is no what's the aggrieved party. No need to be aggrieved party, but in case of writ of certiorari may be submitted by the aggrieved party or in some circumstances by anyone against the local tribunal authority that has abused its power or breached the principle of natural justice. So what is natural actually? What is natural justice? In this regard, we have a lot of landmark decision. For example, Maneka Gandhi versus India, All Indian Report. This is the landmark decision. So this is the on point of the natural justice. The court should give ex officio justicial relief if the application is made by the foreign directly impacted by the lawsuit. However, if the application is made by person not directly affected by the litigation, the court has complete discretion to grant the writ. A writ of certiorari may be issued on the basis of following facts, on the basis of following circumstances like this error evidence on the face of the record. So I don't know that is, but it's not clear to me. Error evidence, what exactly the error evidence according to Evidence Act, 1872, this charge about the examination, see, and cross-examination, or the, what exactly this is the examination in chief, cross-examination, re-examination. So those are the systematic way error evident on the face of the record. By issuing a writ of certiorari, decision of a local or a tribunal can be overturned if there is an obvious mistake of law on the face of the record. So on this point, like this, the system may where advocate journal. I'm in live class. So after finishing this lab video, I will discuss with you in terms of reparations to the high cultivation and the infringement of natural justice. Well, so how can actually a person aggrieved can file a writ of certiorari? Number one is error evident on the face of the record. And the second one is infringement of the natural justice. And the third one is error of jurisdiction. If the lower courts has no jurisdiction at all to decide a case, and that's why this the systematic way in terms of jurisdictional fact. So insufficient jurisdiction, what exactly the writ of certiorari may be granted against a local or tribunal that acts whether jurisdiction exceeds its jurisdiction or fails to exercise the jurisdiction conferred in it by law. And then last one is number 4. In jurisdictional factors, insufficient jurisdiction may also result from the absence of certain preliminary facts that must exist before a court exercise its authority. These facts are referred to be jurisdictional or the collateral. Collateral. No one is watching this video, so as we're using correctness. And that's why the live video actually but Shakib Mahmood prescribed that how you are not able to speak in what in such a way that this the national phenomenon. So the Shakib Mahmood prescribed that national phenomenon is not being practiced from the side of mine exactly, and that's why it is the hampering system not to understand from the side of Shakib Mahmood. You have no power to understand whether this is the what exactly that the national conducting class approach or not. You are the, what can say, genius student and not to understand the language of mind. So it is hampering system with the organic or the organic system, hearing system of you hearing. What the, yeah, and the series that's, oh my God, what an approach. I don't know, Sarani said this, I don't know what exactly wording is killed from the side of Shahid Islam. Okay. Case reference. Then the Secretary Ministry of Home Affairs versus Kali Ahmed Pori, a DLR Appellate Division 170. This is the landmark, and then another of citations, 48 DLR Appellate Division 20, page number 20. Even though the salute is silent, notice must be given if a person's words interest favorably or the character is to be impacted. So this is the natural systematic way conducting the class, Mr. Shakib Mahmood. You have no power to comprehend this language of mine, and that's why it is very much boring to you. And you have no power to understand what I actually deliver to you. If you have any power, or skilled, if you are the skilled person, that time it is very much hearing system. Just prove it to yourself, like from the side of Shakib Mahmood to the online dunya. Just discuss in tracking in such a way. How can you actually comprehend? How can you actually captivate the audience or the viewers in the online dunya? You have no power at all, and that's why it is the what can say sham for you exactly, as you are the ignorant not to understand the language of mine. You are the what can say listen to grasp the language from the side of Hiro Alam. You are the listen to grasp the language from the Asif Nuzrul. You are the Bhaktu from the side of the Dr. Yunus, that the Mew Mew, and that's why it is the very much boring to you. You can't understand the, how can you identify Jati Manush Chinlona. So this is your systematic way. You are the follower of the, what can say, Pinaki. You are the follower of Ilyas Sahib. And that's why it is very much boring for you exactly not to understand, not to comprehend the language of man. This is the natural, what can say, approach, inherent power of mind to discuss in terms of several aspects. But it is very much sham for you, Mr. Shakib Mahmood. You have no will in our society. If you have no believing approach, just ask through the online dunya. Just they are the, of course, you are the, what can say, very much ignorant person in our society. And that's why it is very much boring. Whether yes or not. If not, please challenge should be thrown from the side of you exactly. So the case goes, Secretary Minister of Home Affairs versus Ali Ahmed Fori, the other appellate division 170, or the citation may become 400. This is the 48 DLR. Whether this live video is running or not. Of course running. Well, of course running. So even though the statute is silent, notice must be given if a person's right, interest, preparing, or character is to be impacted. When the law mandates service of notice not to sound, please, soundproof room should be maintained. Even though the statute is silent, Mr. Bajid, outside please. Even though the statute is silent, notice must be given if a person's right, interest, property, or character is to be impacted. When the law mandates service of notice, the authority cannot evade this obligation. Regional Transport Authority of Dhaka versus Mumin Madur Company, 1958 of Tandiala 2000, of course, 284 maybe that the phase number. A writ of certiorari was granted when a quasi-judicial entity such as a regional transport authority issued an order negatively impacting a person's interest without his knowledge. Ashraf Ali and others versus Bangladesh, 5 VLT Appellate Division 261. Maybe the learned judges of the High Court Division exceeded their jurisdiction when they exercised their certiorari authority to overturn the decision of a like S.K. Shakib and Shohid Islam and Shakib Muhammad. So next one is the third one is the writ of mandamus. Mandamus is Latin for we command. Oh my God, we command. We have all the commander to command someone to do something. But writ of mandamus, that's a very curve. What is an individual? Of course, an individual's corporations, like a government, to perform a defined public duty related to their office. So our main tone in terms of a writ of mandamus, we command. This writ is issued when a law court has refused to exercise the jurisdiction vested in it, or when a public official has refused to comply with the law in accordance with the subclause 1 of subclause A of the subparagraph 2 of the article, oh my god, 102 of the Constitution. Of course, this is the wrapped Constitution. The High Court Division may direct a person performing tax related to the affairs of the Republic or local authority to comply with the law to contractual rights are breached. The applicant must demonstrate that he has a legal right to the fulfillment of a legal obligation by the individual or entity against whom the writ is set. The following requirements must be met by the petitioner before a writ of mandamus can be issued. The first one is the legal theory. To maintain the legal theory, if someone is not actually able to actually observe the legal theory at the time the writ of mandamus has come into force before us. A legal obligation must have been imposed on the authority, and the fulfillment of the obligation must be mandatory, not voluntary or discretionary. There must be a right for the applicant to compel the opponent to undertake some obligation. Therefore, if the government can turn its allowance to its employees at its own discretion, there is no legal obligation and a writ of mandamus. Have you understood what I delivered to you, Shakib Muhammad Shahid Islam? You are the ignorant, most of the ignorant students living in our marginal area, even in Dhaka city, cannot be fought against the government for fulfillment of such theory. Such a theory must be state theory, for example, imposed by the Constitution, another statute, or some rule of common law, but should not be contractual in certain circumstances. However, the writ of mandamus may be issued for the enforcement of a such theory if discretionary power is conferred on the authority and statutory provision are made for the exercise of such power. This obligation must be a public character. A writ of mandamus may be issued if the public authority vested with the discretionary power abuses the power, exercises its acts maliciously, fails to apply its mind, or takes irrelevant circumstances into account. This is the number one. And the number two is legal privilege. What exactly the legal privilege? The petitioner must possess legal standing. If you have no legal standing, you are not allowed to file a writ petition from the side of the writ of mandamus. So, the petitioner must possess a legal standing. Thus, when a petitioner claims that he was passed over for promotion by the government and it was determined that he was not qualified for the position, his petition was denied. Number three is demand and refusal. What exactly the demand? A demand for justice and its denial must precede the petition for a writ of mandamus. In Halsbury's Laws of England, it is stated as a general rule that order will not be granted unless the party complained of knew what he was required to do, so that he could whether or not to comply, and it must be shown by evidence that there was a distinct demand of that which the party seeking the mandamus wishes to enforce, and that demand was refused. And the number four, good faith. So what is good faith? It is known to you under section 52 of the Penal Code, exactly 1860. It is quite clear to you that the good faith. So there is a criteria, this is the element of the writ of mandamus is that the good faith. A request for mandamus must have been submitted in good faith and without any ulterior motive or covert objective. Even though a petition for mandamus is filed in good faith, it will not be granted. Oh my God. It will not be granted if it is intended to honor the respondent or exact personal revenge. So in this regard, there are several case law reference. For example, the first one is the Government of Bangladesh. Government of Bangladesh versus Juriuddin Ahmed. 1 bill, the ACD, page number 304. So in this case, mandamus may be issued even though no demand for justice has been met previous to the filing of the writ petition. If specific circumstances suggest that a demand for justice would be useless. Oh my God. Walid Ahmed Chaudhary versus Mahbus Haq Chaudhary, ADLR 429, maybe 1956, that the landmark judgment of mandamus will not be issued unless the foreign seeking it has not only stated on the affidavit that he is demanded of the foreign against who was mandamus is sought to be imposed by the writ and such demand was refused. But also satisfied the code that is a principle that has been universally accepted and insert upon essential and invariable condition for the issuance of this very writ. And then number 4, writ of prohibition. Writ of prohibition. So how can you actually understand or comprehend the writ of prohibition? And the triumph of the common writ in Bangladesh is called the prohibition. The term prohibition refers to the preventive writ. Mahbub Alam are watching this video. Hossein bin Nahid is watching this video. Shakib Mahmood is left from this live video. Why? He has no power to understand the language of mind, and that's why the boring feeling approaching power is prescribed by him exactly. Shakib Mahmood. So you are the ignorant person, so you are not allowed to speak in such way স্বাধীন মূর্খের কোনো স্বাধীন থাকে না. And the type of common writ in Bangladesh is called prohibition. The term prohibition refers to a preventive writ. It empowers the High Court Division to prevent a court, tribunal, authority, or person from engaging in conduct that is prohibited by law. A writ of prohibition is appropriate when there is a lack or excess of jurisdiction, an abuse of power, or violation of the principle of natural justice. Something has been immersed here. If judicial or quasi-judicial authorities issue a warrant that is illegal or exceeds the court's jurisdiction, the aggrieved party may be filed a writ petition with the superior court, for example, the High Court Division of the Supreme Court. And if the court finds the complaint to be valid, it may issue a writ of prohibition against the lacquer or the district judge, etc. Oh my God. So here is the core point is that how can you actually distinguish among the writs? So here is the optional, there must have been the aggrieved party. Must have the aggrieved party. No one is aggrieved, and then no caution may arise in terms of writ of prohibition. So the landmark decision, how can actually writ of prohibition may be issued on the following grounds. On what grounds exactly the writ of prohibition may be issued from the side of the aggrieved party in point of absence or excess of jurisdictions. What exactly the absence or the excess of jurisdiction? And second was the violation of natural justice from the side of Maneka Gandhi versus Union of India. And the statute's unconstitutionality. So what unconstitutionality, for example, this is the 8th Amendment case, or the 5th Amendment case, Italian Marble Works Limited case, and the Berubari case, 3rd Amendment case, for example, ETB Limited versus Chaudhary Mahmood Hassan case, and the Marbury versus Madison from the side of the 1803, from the side of USA, the landmark decision in terms of judicial review. That the unconstitutionality, when we find that term the writ of prohibition may be proceed, maybe come into force to actually statutes unconstitutionality. This is not exactly the statute. What exactly the statute? You know, the Parliament Act. Of course, the laws made by the Parliament is called Act. So what is the difference between the statute, laws, act, legislation? Just prescribe your views, dears and viewers. Violation of fundamental human rights. If the fundamental human rights is being violated, that time the writ of prohibition may be come into force to actually keep the opportunity. Oh my God. When the lack of jurisdiction is clear on the face of proceedings, not only the injured party, but also third party may file a motion for the prohibition. Third party, the rational underpinning this rule is that usurpation of the authority constitutes a breach of royal prerogative and an insult to the crown. Therefore, it is irrelevant who informs the court about the usurpation. However, administration authority cannot be prohibited from performing administrative, executive, or ministerial duties. Similarly, it do not lie against the legislature to prevent it from the passing or enforcing a law. I don't know that this is the system. However, administrative authority cannot be prohibited from performing administrative, executive, or ministerial duties. Similarly, it not lies against the legislature to prevent it from the passing or enforcing a law. So it's the fucking approach from this side. And that's why it is the Ainagor and the Hawa Bhavan will be built in day by day. So the titular head presidents, namely presidents, cannot play a vital role in our country. What can say that the dictatorship is being practiced in our country, and that's why, however. And the rate of coherent, last of all, rate of coherent, the final type of rate in Bangladesh. Yes, this is the final type rate in Bangladesh. That will be the discussed in the article is called the rate of coherent. So the term coherent means what is your authority? What is your authority? Just say me, what is your authority? On what ground and what on which authority you are claiming this post? The term quantum means what is your authority in Latin? It is judicial remedy against an occupant or usurper of an independent public office, franchise, or liberty. It imposes jurisdiction and authority on the judiciary to control executive conduct in terms of making appointments to public position contrary to the relevant statutory provisions. So protecting citizens from being denied a public post to which they may be entitled. Oh my God. Whether yes or not, in a writ of quorum, the petitioner challenges the legitimacy of the claim of the incumbent of a public office. Therefore, this writ can be requested by anyone. Oh my God. Here is the anyone. So it is the core point is that there is no need to agree party. No one is to be treated as the aggrieved party. Anyone can file such type of writ petition to the High Court Division. So therefore this writ can be requested by anyone regardless of whether they have personal stake in the outcome. The purpose of this writ of quo is to prevent a person who has illegitimately seized a public office from remaining in that notion. For example, this is the present government, for example the Asif Nazrul. You know, this is the systematic Nur Nahid Mughdo's government, that the ad interim government from the side of the Dr. Yunus is practicing in such type of illegitimately seized public office from the remaining in that position. Therefore, application from the system, the mob justice is not being practiced here. Therefore, the application for writ of quorum to challenging the legitimacy and validity of an appointment to a public position may be filed any private individual. This is the present government is practicing such type of power. So this will be the bidding system when the another party is in power. That time there will be the. So what a fucking approach. Therefore, an application for the writ of quorum to challenging the legitimacy and validity of an appointment to a public position may be filed by a private individual, even if he has no personal stake in the matter. Before the quorum can be issued to the following specification must be met. Before issuing the writ, the court must be convinced that the post in question is public in nature and that the occupant lacks the legal authority to retain set up office. This writ will not lie in relation to a private office, such as a private school's governing power. Of course, this is not the private approach. The public, for example, the the office holder Nahid, Mr. Nahid, and the Asif Nozrul, and what exactly the Dr. Yunus is practicing in such way. The several posts from the police side, the public service from the side of the public organization. Exactly the holding power, this is not treated as to the private schools governing power. This is not applicable to this fact. The position must be substantive in nature. What exactly is substantive in nature? The phrase substantive correct indicates that the office's caution must be independent. So, the office must be created state what the constitution. This is a fucking approach in our country. Exactly those who are the party in power, they are actually forgetting this the hypothetical approach or the justice, good conscience, and what exactly that the follows and ethical or the morality. They are forgetting the morality, ethics, and religion, and they are practicing, for example, Jerejai Lonkai Shei Hoi Rabon. So the next thing is that the position must be substantive in nature. The phrase substantive correct indicates that the office in question must be independent. The office must be created by the statute or the constitution, but there is no constitution at all in our country. But the earlier constitution in our country, this is the wrapped constitution, only one person is given a power. This is the power is dictatorship. Very much important that the hearing system like this, the fascism. So what exactly the fascism? It is widely used word, the term in terms of mob justice in our existing society, that the fascism is being practiced in our country. So this is the fucking approach from the side of the law makers of the parliament. This is not the holy parliament. The holder must have made a legitimate claim. Oh my God. I don't know this, the office must be created by statute or the constitution. The holder must have made a legitimate expectation claim to the office. But unfortunately, those who are the power, actually those who are exercising power, of course, they are the party in power, they can't actually, they can't tolerate the opposite party in a party. Opposite party may be BNP, maybe Jamaat Shibir, maybe whatever may be exactly. Now this the ad interim government proves that aspect again. So this is sham for the whole nation. We have no power at all to build a nation fruitful and developed country like the we're raising our hand and raising our hate in the world. And we can easily challenge the European countries, like we can challenge the America, Russia, China, Japan. But unfortunately, the birthplace of Shahid and birthplace of what can say like the Shakib Muhammad is the very much ignorant students in our country, and that's why they can't understand the language of mine exactly. This is not the national phenomenon. Quantum is a discretionary remedy, and the petitioner has no inherent right to obtain this right. Taking into account the facts and circumstances of the case, the court may decline to grant this right. This may include situations when the issues of writ would be the vexatious, whether the petitioner has consented or whether it would be the pointless since the incumbent of the office in question has resigned. It may also be denied if there is a simple electoral irregularity. So this is the birthplace of the Shakib Muhammad, and every person is the dull student in our country. A writ of quorum may also be denied on the grounds that petitioner has access to alternative statutory remedies. Thus, when it was sought to as a writ of quorum against a member of the state legislature, it was denied to the grounds that the election present provides an alternative remedy. And this case law's reference in this regard is the district register and others versus Muhammad Abdul Rab Mia, 19 BLD Appellate Division 2004. This is the page number. The petitioner did not appear before the red court to establish a public right. Rather, he did so to further his own interest. A coup warrant cannot be used in a manner for such a purpose. So the personal matter is not taken into consideration in terms of writ of quo warranto. That can be termed as to the public matter, the public interest litigation that is totally known to Dr. Mohiuddin Farooqi versus Bangladesh. That simplicity and the brevity and in a nutshell, this is treated as to the fair case. So the Shahzada Parveen versus Bangladesh 40 DLR Appellate Division 178 Press Ahmed Nazir versus Bangladesh 27 DLR 199 and the Landmark Alam Arahok versus Bangladesh 42, DLR 1908, and no public office can be held without a legitimate claim to that office. So that's a vanishing movement, and that's why this is the totally emerging system at time in regards as to the which petition to the High Court division. It is very much important to understand and comprehend that to pass in that very High Court permission exam 2025. So this is the highlighting approach to understand, to comprehend the lecture on point of writ petition to the High Court division. Today's number. Bye bye.